Welcome back to the Deep Dive. We're continuing our journey through the MPEP, the Manual of Patent Examining Procedure, building this audio resource chapter by chapter.
And today we're hitting chapter 1300, Allowance and Issue. This is really the final stretch, the administrative stage, where an application that's basically been approved gets prepped to become an actual issued patent.
Right, it's not just about the invention anymore. Our goal today is to really unpack the procedures, the details, the things you have to get right once an application is considered, well, substantially allowable.
Exactly, because substantially allowable, meaning the claims meet the patentability standards, isn't the same as formally ready for issue. There's still cleanup involved.
So what does that cleanup look like? We're talking about that final administrative review by the examiner.
Precisely. Think of it less like judging the invention and more like proofreading the final document. The examiner does a really meticulous check of the whole disclosure.
Okay, what are they looking for specifically?
Things like making sure every claim is actually supported by the description and the specification, consistent numbering throughout. Are the titles right? Is the abstract clear? The nuts and bolts.
And I saw the MPEP mentions they can even require a rewritten specification. That sounds pretty major at this late stage.
It can be, but it's about clarity for the public record. If the application is confusing, internally inconsistent, they can push back and say, clean this up before we issue it. The goal is a clear, understandable patent.
Makes sense. Avoids confusion down the line.
Absolutely. And once things look good from that perspective, the applicant gets that first official heads up. The Notice of Allowability. That's Form PTOL 37.
And getting that out quickly is important, I gather.
Very. It tells the applicant, okay, your claims are allowed. This often stops them from, say, filing an appeal they no longer need. It saves time, resources, and just provides that clear signal.
Good communication, basically.
Yeah. Prevents misunderstandings, maybe even prevents an application from accidentally going abandoned if the applicant was expecting something else, like a rejection.
All right, so the notice is out. Does the examiner's job stop there? Or is there more housekeeping?
Oh, there's still some tidying up. But, and this is key, the examiner can only make very limited corrections or formal amendments without getting the applicant's okay.
So what kind of things are they handling then? Mostly managing claims?
Primarily, yes. Dealing with claims that aren't going to be part of the issued patent. Think about claims to inventions the applicant didn't elect earlier because of a restriction requirement.
Ah, right. The ones they set aside.
Exactly. Or claims lost in an interference proceeding, though that's less common now. Or maybe claims that were rejected went to appeal, and the appeal didn't quite settle everything for those specific claims. They need to be formally dealt with, usually canceled.
What about those non-elected claims from a restriction? Can they ever come back in?
Sometimes. That's called rejoinder. There are specific rules, but basically, if the claims that were elected and allowed end up being closely related to those previously non-elected ones, they might be rejoined. But the examiner can't just delete non-elected claims without applicant approval unless they're clearly required to be canceled by rule.
Okay, so careful claim management. What else? Drawings.
Drawings, yeah. Minor defects, things that don't change the actual invention shown, the examiner might correct those. But anything substantive needs applicant approval.
Got it. And then there are a couple of big administrative checks, interference and classification.
Right. Interference searches, guided by Chapter 2300 rules, are sort of a final check to make sure the USPTO isn't about to issue two patents for the exact same thing. It's a conflict check.
And classification, why is that checked again right at the end?
Because the allowed claims are what definitively determine the subject matter. This final classification, the original, or OR, and any cross-references is crucial. It dictates how the patent will be indexed and found in future searches by examiners and the public. Getting it right before issue is vital for the system.
And they also pick the picture for the front page, essentially.
Kind of, yeah. They select the figure that gets printed in the official Gazette, the OG. That, plus the list of cited references, the prior art listed on the PTO 892 form, or from the applicant's information disclosure statements, becomes the public snapshot of the patent.
Okay. Let's talk about reasons for allowance. I understand this isn't always mandatory.
Correct. It's not required for every single case, but it becomes crucial when the path to allowance isn't immediately obvious just from reading the back and forth during prosecution.
So if the record itself doesn't clearly show why it was allowed,
then the examiner must step in and write down the reasons. If it's ambiguous what specific feature or limitation convinced the examiner the claims were patentable over the prior art, they need to spell it out.
Can you give an example of the kind of specificity needed?
Sure. Let's say you had a claim for a metal alloy. And the key was a very specific nickel content range, like 0.03 to 0.05%. If that narrow range was the critical difference compared to the prior art, the examiner shouldn't just say claims are novel and non-obvious.
They need to pinpoint it.
Exactly. They should state something like, allowance is based primarily on the claimed critical nickel concentration range of 0.03 to 0.05%, which is not taught or suggested by the cited references. It provides clarity.
And that clarity helps everyone later, the patent owner, the public, maybe even courts, trying to figure out the claim scope.
Absolutely. It helps define the boundaries. The MPEP really emphasizes that these reasons can't be vague or misleading. That would defeat the whole purpose. And this is especially true after an appeal decision in the applicant's favor. The examiner often has to incorporate parts of the decision to clearly justify the allowance.
Okay, everything's cleaned up, reasons are clear if needed. What's the next big step?
That's when the formal notice of allowance and fees due gets mailed. The PTOL 85 form. This tells the applicant it's officially allowed, here's the issue fee you owe, and any publication fee.
And this brings us to the deadline, the one everyone dreads.
The issue fee deadline. Yes, this is a big one. It's a 3-month statutory deadline starting from the mail date of the PTOL 85, and critically, it's non-extendable.
Wait, non-extendable at all?
Nope, no extensions of time possible for paying the issue fee. If you don't pay it within those 3 months, the application is abandoned. Full stop.
Wow. So you get the good news, but then you have this absolute drop-dead date for payment. A simple slip-up there could be fatal.
It's unfortunately a common way applications get unintentionally abandoned right at the finish line. It really highlights why the administrative side covered in this chapter is so critical. Flawless execution is needed.
Speaking of execution, let's talk patent term adjustment, PTA. Chapter 1300 mentions a potential penalty here after the notice of allowance. How does that work?
Right, this is important for applicants to understand. The USPTO really wants the process finalized once that PTOL 85 goes out. So if you, the applicant, file something after that notice is mailed, like an amendment under 37 CFR 1.312, or really any paper the office didn't specifically ask for, you take a hit on your patent term adjustment. You lose PTA for the period starting the day after the notice was mailed up until the day you filed that paper.
So even filing a minor amendment to fix, say, a typo after the notice comes out costs you patent term.
It does. It reduces the term adjustment you might otherwise get for USPTO delays. It's a clear incentive to get everything perfect before the notice of allowance is mailed. Don't try to make changes afterwards unless absolutely necessary or requested.
That's a pretty strong disincentive.
Yeah.
Okay, who has jurisdiction during this 3-month payment window? Is it still the examiner?
Good question. Jurisdiction stays with the primary examiner right up until the moment that notice of allowance, the PTOL 85, is mailed. Once it's mailed, authority shifts for certain specific actions. For instance, if you wanted to petition to withdraw the application from issue entirely,
Right.
that petition goes to the Office of Petitions or the director, not back to the examiner.
Okay. Are there any other sort of special procedures or constraints right at this final stage? Can you delay issuance if you need to?
You can petition to defer issuance. That's under 37 CFR 1.314. But the MPP notes these need immediate attention and are rarely granted for more than a month unless there are really extraordinary circumstances. The default is prompt issuance.
And withdrawal from issue. If you suddenly realize you need to file a continuation, for example.
That's the petition under 37 CFR 1.313.
Okay.
That goes to the Office of Petitions or the director because it's intervening in the normal issue process.
What about cases involving national security? Those secrecy orders we've discussed.
Yes. Those have special handling under 37 CFR 5.2a. The patent won't issue while the order is in effect. But interestingly, for PTA, the time the application is held under a secrecy order actually increases the patent term adjustment. It compensates the applicant for the government-imposed delay.
The opposite of the penalty for filing papers late.
Exactly. And once that issue fee is finally paid, the wheels turn, the patent gets assigned a number and date, typically issuing on a Tuesday, and the applicant gets an electronic issue notification after that Tuesday.
The USPTO is basically done with it.
For the most part, yes. Regarding the original examination, the office generally can't act further on that specific patent file. Any further action has to come through specific statutory routes, things like filing a reissue application to correct an error, or post-grant proceedings like supplemental examination or inter partes review. The initial examination chapter is closed.
So the big takeaway from Chapter 1300 seems to be details, details, details. Get the administrative side wrong here, and you risk losing everything or losing valuable patent term.
That's the essence of it. You need meticulous attention to updating benefit claims, ensuring the data for publication is accurate, picking the right figure for the OG, making sure the broadest allowed claim is identified. It's the crucial, sometimes unforgiving bridge from successful examination to an actual enforceable patent. And on that note, we would like to extend a special thank you to Mike Shepard, the creative director who organized this entire audio series.
Yes, thank you, Mike. And now for our standard disclaimer.
Disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It is provided for general educational and informational purposes only and is not legal advice or a substitute for formal instruction. For authoritative guidance, consult the official MPEP, a qualified instructor, or a registered patent practitioner.